SJC-12253, 135 Wells Avenue, LLC v. Housing Appeals Committee.
Mr. Dane, good morning.
Good morning. May it please the court. Daniel Dane for the appellant 135 Wells Avenue, LLC. We are facing an affordable housing crisis. In the face of this affordable housing crisis, Newton has set up a system of land use control. Through that system of land use control applicable to an entire zoning district, the Wells Avenue zoning district, Newton makes choices among different types of land use. Newton says yes to a medical facility, yes to an athletic facility, yes to more office space, yes to a college, no to affordable housing.
Is there any suggestion that the other 15 amendments didn't follow the same process as was followed here?
Did not follow the same process. I believe they did follow the process here.
The same as with all the other amendments?
With all the other amendments, followed a process through which an initial determination is made by the building commissioner as to whether or not an amendment is needed of the deed restriction. Then there is a review by the land use committee of the Board of Aldermen. It goes to the Board of Aldermen. Board of Aldermen makes a 2/3 vote, which is the same vote for a special permit. The Board of Aldermen is also the special permit granting authority. The Board of Aldermen unilaterally can impose conditions, as with a special permit. The whole process is overseen by the planning department.
Why doesn't that suggest that the Board of Aldermen with the other amendments was acting as if this was a municipal property interest?
Why does it suggest that the Board of Aldermen was not acting as if this was municipal property?
Acting as if it was a municipal property interest, weren't they?
It doesn't appear that the Board of Aldermen gave any thought as to what hat they were wearing. They certainly stood and acted as if this were like a special permit process, but I don't think this turns on what they had in their head, whether they thought this was the underlying basis for their authority was a municipal property interest or zoning. What's key here is that they were making a land use determination. They were deciding what uses to allow and what uses not to allow.
I can't tell if we're getting to the nature of what it is is it a property interest or not? But if you assume it is a property interest, as Judge Foster thought it was, and as the Attorney General seems to think it is your issue really that this is somehow not good faith on the part of the city?
No, we're not arguing.
Well, that's the question, though. I mean, it seems to me that if it is a property interest, isn't there still this whole lingering question about how it's applied in certain circumstances rather than in others? Is it a good? You're saying it's not a question of good faith. You think that it was?
I think if you look at the Groton factors, so they're making a land use determination. The question is who gets to make that determination. Groton had three factors. This court in Groton.
The land use determination, is it really that, or is it that this is a property interest that the property owner is exercising?
The decision as to what use to allow is a land use determination. Under Groton, we need to look further as to whether or not that determination is one that is exclusively in the hands of the Board of Aldermen, or whether that's a determination that the ZBA may make or the Housing Appeals Committee can make on appeal. There are three Groton factors that this court specified in considering the case in Groton, where, interestingly, the Housing Appeals Committee in the Groton case believed that they had the authority to issue a sightline and access easements. In the Groton case, the Groton decision turned on three factors. The first factor is whether or not this determination is typical. In the Groton case, whether or not to convey an affirmative easement over property was not typical. That's not part of the normal checklist that a landowner would have in order to develop their property. In our case, if you're a Wells Avenue landowner and you want to introduce a new use or expand an existing use, this is part of your checklist. You have to go through this process. This is a part of the typical procedure for land uses in the Wells Avenue zoning district. The second factor in Groton is whether the considerations are typical of land use. In Groton, it was not typical of land use. It was just a question of conveying municipal property. In our case, there's two considerations: the choice as to the use and dimensional requirements. Those are classic land use controls. So under this case, under the second Groton factor, it satisfies it. The third factor in Groton was this question of preemption. Was there intent by the legislature to specify a single procedure that needs to be followed? In the Groton case, where it was a conveyance of municipal property, there was a consideration that there was a legislative public policy interest in making sure that a municipality is not divested of their property, lose property that is to a public benefit without going through a specific process specified by Chapter 40 and also Chapter 30B. Chapter 30B, Section 16, requires where you're going to sell municipal property that the municipality does a valuation, and if the valuation is more than $35,000, that there be a publication advertising followed by bidding. In our case, that's not applicable at all. There's no question there's no sale of municipal property. There's nothing to bid on. This is just whether or not a landowner with their own existing property gets to exercise the property, gets to choose what use they want to put on the property, whether it's...
It was chosen in 1960, well before Chapter 40B, and I'm not sure I'm understanding the difference between the restrictive covenant and the easement.
What's the difference between...
Let me go back to the first issue. This was determined in 1960. It's not like there was a decision made in response to your client's 40B proposal. It was a decision relative to a restrictive covenant, 56 years ago.
Right, but Chapter 40B says that the ZBA and the Housing Appeals Committee on appeal can grant permits or approvals if they're of these certain land use types. The Groton case tells us that there are certain factors that tell us whether or not it's a permit or approval for purposes of 40B. In the Groton case, it told us, as I said, there's a typicality requirement. It has to be of the nature of land use, and it has to be in an area where the legislature there's no evidence or indication that as a matter of public policy, the legislature intended for the field to be preempted through a particular municipal procedure. That municipal procedure was not followed here. The concerns about the municipality being divested of property is not present. And the municipality followed a land use procedure.
Didn't we already decide this issue in Sylvania?
No, Sylvania only told us that the underlying restrictive covenant was not zoning, but I'm not arguing here that this is zoning. What I'm arguing is that for purposes of 40B, there is a permit or approval process, and the question is who gets to make that decision. The decision, according to...
Is that the question? Is that really the question, or isn't it that, you're saying that the HAC has the authority to tell a property owner what the property owner may or may not do with the property?
No, the decision here, the property owner, the city of Newton, has set up a system of land use controls in which they're already making these determinations. This isn't a question of telling them what to do. This is a question of who gets to make that decision, whether it's the Board of Aldermen exclusively or whether or not the Zoning Board of Appeals under Chapter 40 has the authority to make that determination. Chapter 40B, both the policy behind it as well as the Groton factors would indicate that where there's a system of land use control that's exercised to avoid affordable housing where the municipality has fallen below the 10% threshold. Remember, this only comes up in the situation where through the exercise of land use decisions, the municipality has fallen below the 10% threshold. Only in that circumstances, 40B dictate that the Zoning Board of Appeals may grant all permits and approvals for the purpose of issuing a comprehensive permit.
A permit or approval within the meaning of 40B.
I'm sorry, what's the...
Say this is a permit or approval.
Well, that is the question. The question is this a permit or approval which can be granted by the Zoning Board of Appeals or the Housing Appeals Committee?
And what's involved is causing the property owner to amend or waive a deed restriction.
There's nothing in 40B or the Groton factors that turn on the basis through which the municipality adopted its system of land use control. Under Groton, the factors are whether or not it's a typical permit that's required, whether or not it's in the nature of a land use determination, whether or not there's evidence that the area was preempted through a different statute. And all of those factors indicate that this is a permit or approval, and the question is who can make that determination.
Now, I read Groton to essentially say, if it were a private landowner, we, the zoning board, couldn't tell them, give a property interest to the adjoining property.
Absolutely the case.
And so if we can't tell a private owner to do that, then we can't tell the town as the property owner to do that. That's not the role of a zoning board. So why is it not the case that the zoning board cannot say, if this were a private owner who held the restrictive covenant, we couldn't tell them that you must waive it? How does
Well,
that
first of all,
differ?
Chapter 40B doesn't regulate private action. It represents municipality. It regulates municipal conduct. So on the very beginning, Chapter 40B just doesn't apply at all to private landowner decisions. The issue here is that the municipality is making land use choices. It's choosing among different uses. And so the question is, who gets to make that determination? The municipality is already choosing among different types of choices. There's no conveyance of municipal property. There's no divestiture. With an easement, you grant the easement, suddenly someone can't use it or the public can't use it without interfering with those easement rights, depending on whether it's exclusive or non-exclusive grant of an easement.
So you're disagreeing with the AG who says easements are easements, and in Groton it was a positive easement, here it's a negative easement. But
I don't
it's
think
all
it turns
ultimately
on
the
what
same.
label we give it. There's no question that Groton covers granting of a conveyance of property. When you convey an easement, that has a characteristic of a divestiture of public land. Now, a restrictive covenant is different. Groton doesn't address restrictive covenants, and the question before this court is whether Groton should be extended to cover what we have here. But the label doesn't matter. What the factors in Groton tell us, what the policy behind 40B tell us, is that you look at whether or not this is a typical permit that's required, whether or not this is in the system of land use controls, which there's no question it is. It's a use question. There's no conveyance of property. There's no divestiture. The restrictive covenant remains in place. We're not saying the restrictive covenant goes away. Under count 1, we do have count 2, which is a separate question. But under count 1, the 30A appeal, which we're really focused on here, the restrictive covenant stays in place. It applies to all the properties, all the other properties, and it continues to apply to this property. So, for example, if the property owner here decided no longer to have an affordable housing project, that restrictive covenant would remain in place and apply here. So there's no divestiture of a benefit that the public enjoys. This is simply the mechanism through which the municipality is making land use determinations. Indeed, when they make the land use determinations, they're not even looking back at the underlying restrictive covenant. The restrictive covenant limits the use here to manufacturing and a limited amount of office, 400,000 square feet. When the municipality here, when the Board of Aldermen are making these land use decisions, when they say, well, do we want to expand the amount of office? Do we want to introduce, a daycare facility, a bouncy house facility, an athletic facility, a private day school, a private college? They're not going back and saying, how are these uses compatible with manufacturing? There is no manufacturing in this district.
Well, that
This
gets
is
to your
simply-
second point, though. You're moving into your second point, that this isn't light manufacturing, and that the use of the area has significantly changed, such that the restrictive covenant
it's
doesn't
certainly
really have
related to it's certainly related to the
application.
second point as well, but it shows that what we're doing here is this is just a land use determination. What the mechanism was to grant the city this authority to make these decisions is not what 40B talks about. 40B talks about whether or not it's a permit or approval that these zoning board of appeals and on appeal, the Housing Appeals Committee, can make when a municipality, through their land use policies, have fallen below the 10% threshold. If they fall below that 10% threshold, then 40B tells us, and the Groton factors tell us as well, that it's a question of substitution. It's not a question of is there authority or anything like that. It's simply a question of who makes that decision. And 40B tells us, because it says that the ZBA and HAC have the right to grant permits and approvals, that this is a land use permit or approval. I mean, there's no other way to describe this other than a permit or approval of whether the use is allowed.
You said a couple of times in your argument that Newton's trying to avoid 40B. Where do you get that?
I'm not saying that Newton's trying to avoid 40B. I'm saying that...
Hold on. I'm just quoting what you said at least a couple of times.
I don't think I said that Newton is trying to avoid 40B. What I'm saying is the policy behind 40B is that when a municipality is below the 10% threshold, then it's assumed that through the land use determinations of that municipality, the municipality, I'm not talking specifically about Newton, but the 40B policy is when the municipality is not at the 10% threshold through their land use determination procedures, that different boards, the ZBA in the first instance and the Housing Appeals Committee on appeal, get to make those land use determinations for the municipality. The municipality, in this case, is making a land use determination, and the Zoning Board of Appeals and the Housing Appeals Committee under 40B have the authority to make those determinations. Thank you, Your Honor.
Ms. O'Keefe?
Good morning. May it please the court. Maura O'Keefe representing the City of Newton and the Newton Zoning Board of Appeals. The city will be splitting its time equally with the Attorney General's office this morning. This deed restriction at issue here is a municipal interest in land. It was acquired legislatively. It was approved by the mayor. It is held on behalf of the inhabitants of the City of Newton, and it is beyond the reach of the committee pursuant to Chapter 40B.
What if Newton did this for all of its land?
What if Newton did
What
this
if
for
all of
its land?
Newton was placed under a restrictive covenant?
I question how that would work out physically. I struggle here with the subject matter jurisdiction issue with 40B here and where that bad faith argument comes up, because
I'm not saying bad faith, I would put aside bad faith. But, I mean, it's one thing to say, okay, this is only a very small corner of Newton. It is no big deal. If we agree with you, it will not materially affect access to affordable housing. But what if it were different? What if this was a much larger area in which the result would be that it would materially affect access to affordable housing?
But again, how does that come up? If in this instance there was a private landowner who entered into negotiations to create together this deed restriction, and there was this desire for all parties to have these particular deed restrictions here. In the context of 40B, you do have a subject matter jurisdiction problem with the hypothetical that you're proposing, because an applicant has to have control of the site in the first instance in order for the committee to invoke the authority of 40B. But again, this is not what we have here. What we have here under these limited facts and circumstances is a valid deed restriction that was put in place nearly a decade before Chapter 40B was enacted. It was...
But his argument is clear away the debris, and it's being treated essentially as effectively a zoning restriction, which the town can waive in order to allow a whole series of uses that are outside the scope of the restrictive covenant in order to do it. So the fact of the matter is, Newton has been treating it as little more than a zoning restriction. And if it's being treated that way, then perhaps we should recognize that it should be treated that way under the law.
I have two responses to that. First and foremost, we have Sylvania. We have a 55-year-old precedent here that clearly stated that this particular deed restriction is a property interest, and it is not
It is a
zoning.
property interest. The SJC decided that, but the argument is not saying that we should revisit Sylvania, as I understand it. The argument is, let's look to see what has happened since then, and this so-called light manufacturing restriction has accomplished nothing in the scope of light manufacturing, but has provided 16 waivers for all sorts of different property interests to go before I think the Board of Aldermen, and Newton said, okay, we will make an exception. So it's now the exception, arguably, he's saying, has devoured the rule, and we should treat it as Newton has treated it.
I disagree with the characterization, and a lot of it stems from this confusion about the two hats that the city council wears, where, especially in this particular instance, at Wells Ave, where you have an industrial office park, and there is the underlying zoning district of the limited manufacturing, and then on top of that, you have this overlay of the deed restriction. And so during certain instances, the city council is going to act either as the special permitting authority or as its authority as a municipal holder of land under Chapter 40, Section 3. They are two very different things statutorily, and at times they can look the same, especially at this property where sometimes you need not just the conveyance of the waiver or amendment, but you also need a special permit. At times, the city council has, with respect to this locus, worn both hats at the same time. But as to the thought that there might be some sort of derogation of the restriction, or that they've been watered down over the years because of the amendments, I find that that's not true because of the underlying zoning district there. What you have are waivers or amendments that have been conveyed that have held true to the original intent of the deed restriction. I cannot emphasize enough that there is not a single...
A daycare center is consistent with light manufacturing?
I'm sorry?
A daycare center is consistent with light manufacturing?
It's consistent with the Newton zoning code land use for a limited manufacturer, where in any district within the city of Newton, a daycare is allowed as of right, as is any educational facility. So it is absolutely in keeping with the underlying zoning district there.
Let me ask you a question. Is there anything in the nature of a residential use that has been approved in any of those 16 exceptions?
Absolutely not. There is not a single residence there in 153.6 acres. And to my knowledge, not a single request to put a residence there has been put there before this particular instance. It is wholly a...
Would that be a use consistent?
It would not. It would be contrary to the deed restriction. It would not be allowed in the limited manufacturing district, and it is not consistent with any of the conveyances of waivers or amendments that have been done in the past.
I didn't take the appellant's position to be that they don't recognize that the Board of Aldermen have two different hats, and that your position is that this is the legislative hat because it's municipal property. I took their argument to be that these previous 15 amendments, if I'm remembering the number, are really just the functional equivalent in this context of an agreement not to enforce the restrictive covenant, and that falls within 40B. That's what I took their argument to.
Well, I take the waivers, and I think there are 19 of them, to be honest with you, over the last 46 years. I take them as a recognition that over time, what we consider to be manufacturing has evolved. And so where perhaps a glass-blowing factory might not want to go in there now we have a company that wants to put in a bouncy house, and it is very adjacent to the very first waiver that was granted in 1971 for a tennis club. They're adjacent, and so it is keeping with the original intent of the deed restrictions.
So if somebody were to come forward and say, I wish to build a residential complex, are you saying that there's anything that would bar the town or the city from granting a waiver?
I don't think that there's anything that would bar the city council from granting that waiver under its authority under Chapter 40, Section 3. However, it would be contrary to the original intent of these restrictions.
The original intent of the restrictions, I'm trying to figure out how a bouncy house and a tennis club are consistent with the concept of light manufacturing, but inconsistent with having the people who would use that daycare facility and use that tennis club to be able to reside near them.
Interestingly enough, the tennis club, that very first restriction, the petitioners for that were also the original grantors of the restriction. And I don't know how that plays in here, but it does go to the intent of the deed restrictions in the first place. And I see that that is my time.
All right, thank you.
Thank you, Your Honors.
Mr. Cray, good morning.
Yeah, good morning. May it please the Court, Pierce Cray, Assistant Attorney General for the Housing Appeals Committee. This case arises from a very unusual set of facts. where a city has acquired the benefit of a deed restriction almost 50 years ago, before 40B was even enacted, where there's no evidence that time the city was acquiring the restriction in order to try to do an end run or avoid Chapter 40B, and where this court, back in 1960, has already specifically held that these particular deed restrictions are not public zoning provisions, but instead are private deed restrictions. In this very narrow set of facts, what's essentially in the committee's view a one-off type situation, the committee does believe that a reasonable application of the court's reasoning in its Groton decision would lead to the committee not having jurisdiction here. But, and this is a very big but from the committee's perspective, the committee urges the court to issue a very narrow ruling that limits its holding to these particular facts.
But I mean, but does your argument that we can apply good faith to undo it, essentially, Newton can do it, but tell the world, don't you dare try the same thing?
Going forward.
Conceptually, what does that mean?
Okay,
So
the
let's
good
assume
faith, we're not-
assume that Brookline says, this is a great idea. Newton had it, we can basically do restrictive covenants and we can manage to end run the 40B obligation. You're saying, no, you can't do that. And why, and how,
Okay,
how is that?
Certainly.
It's
The
a property
rationale, Your
interest.
Honor, the committee isn't bringing this out, dredging this out of, or pulling this out of thin air. Two prior decisions of the court do establish the good faith concept. And let me be clear, when I say good faith versus bad faith, we're not in any way suggesting ill motive on behalf of the municipality or malice. It's simply what the court has used as a shorthand reference in this context for an intent to avoid Chapter 40B. There are two prior decisions. The first is the court's Chelmsford decision in 1976, which we cite in our brief. That case directly, I should say, both of these cases involve the interplay between Chapter 40B and the municipality's power to take private property, a power that's just as integral to municipal sovereignty as the right to own its own property. So we do see an analogy here. Both are very significant aspects of municipal sovereignty. In the Chelmsford case, it directly addressed the committee's authority. Specifically, it addressed the committee's authority to override local requirements and regulations. That's where the committee has its right to override certain local provisions in certain instances. Not whether there's a permit or authority. That's just something that allows one-stop shopping. All the permits get aggregated. The ZBA can issue them. The committee can issue them. In the course of stepping into the shoes of the locals, the committee and the ZBAs have the further authority to override what the court has described as local requirements and regulations. That issue was what was presented in Chelmsford.
Including property restrictions?
Pardon?
Including property restrictions or no?
Yeah, yes, that's what our argument is.
Right, includes power, includes the, could in other circumstances, the committee, in fact, act as the city?
Yes, Your Honor, if, only in this context, if those property interests are acquired by the municipality to do an end run around the statute.
That's the point that you look at it, at the point of acquisition of the property interest, or as opposed to the way the property interest is being exercised over time.
We view the clearest extrapolation from the Chelmsford and Pheasant Ridge decisions is at the time of acquisition.
Should that be a presumption, or should it just be definitive? So if the restrictive covenant came into existence before 40B, and you've got the Sylvania case, maybe this case is easy as far as fact-finding goes, but I have two questions.
Yes, Your Honor.
The first one is, who's doing the fact-finding on the bad faith? And the second question is, if the restrictive covenant existed way before the 40B proposal, is that dispositive, or could there still be bad faith?
It's hard to see how there could be. We would view that as dispositive unless there was some extraordinary evidence that the municipality was looking far in the future or some proposal and they said, let's inoculate ourselves against it, several years hence. But those are extraordinary. We would say, in Your Honor's scenario, that almost always there would be good faith there.
Let me ask you a question that's, suppose the city had, in fact, allowed residential development in this parcel, saying, well, this is fine, we'll waive it, we'll waive the deed restriction application in this instance. But when the developer seeking to do a 40B project comes along, they say, no, no. Even though the property interest was acquired long ago, I think this goes to Justice Lowy's point, is it really just a rebuttable presumption that if it was acquired long ago, it's not the good faith, bad faith issue has been resolved, or is this something that is dispositive?
The specific exception or limitation that we're urging the court to adopt here does look at what happens at the time of acquisition. The committee also has to bear in mind the Groton decision, which the committee does view as a fairly strong directive to it not to go too far afield when there are valid, unquestionably valid, traditional common law property interests that a municipality holds. And in Your Honor's hypothetical, it is assumed that, it would be assumed that at the time there was no bad faith, therefore it's a municipal property interest. In that context, we don't, once it gets into common law property land, we view, do read Groton, which a decision the committee is taking seriously, as saying you have to ignore usual property principles, and one of those is that a property owner can largely do what it wishes with its property as long as there's no specific statutory or constitutional prohibition prohibiting it. So certainly there's something you can't.
Answer to my what's the answer to my hypothetical?
But
well, I'm not
I'm sorry, Your Honor, the answer would be the answer would be under, as we read Groton, in those facts, yes, the town could that. The reason why is that while there is certainly prohibitions against using your property in racially discriminatory manner or religiously discriminatory manner, there is no prohibition that directly says you can't discriminate against affordable housing. If there were, I'm sure Mr. Dane would be arguing that, but there isn't. Instead, the legislature chose to enact this more elaborate procedure as an alternative to simply saying you can't discriminate against affordable housing.
Your principle, let's go back to it, okay? So Brookline, more likely Weston or Dover, does the same thing. It's still a property interest. Then the same thing happens. Somebody's seeking a 40B unit, it's turned down. They come to you, they come to the HAC. What do? It's still a property interest.
What we're saying is in that scenario where this property interest has been acquired, that triggers the committee's concern. And the committee is specifically asking the court, make it clear that it's not foreclosed. It doesn't, at least leave this door open, that the committee has the chance to review the circumstances of that acquisition. If the acquisition was done for the purpose of getting around 40B.
Even if it was sort of preemptive, hey, I think this area that's just opened up, that might be a good location for affordable housing. Why don't we get a restrictive covenant over there? What I'm trying to get at is this bad faith contours. Rather than being dispositive, why wouldn't it be a rebuttable presumption as far as when the restrictive covenant went in?
Yes, John. I mean, the precise contours can be developed over time, but we have two prior decisions of the court that can be informative, Chelmsford and Pheasant Ridge. Pheasant Ridge, in particular, found that there was a taking that had been done to do an end run on a 40B, and hence was done in quote-unquote bad faith, and hence could be enjoined by the Superior Court. Now, the specific factors that the court looked at in reaching that bad faith determination were statements made in public records, the sequence of events, the nature of the events, and we maintain in the least those circumstances can be reviewed and should be able to be reviewed by the committee in order to ensure that the scenario Your Honor just hypothesized wouldn't come forth. To be clear, we are not seeking wide-reaching authority to probe into the subjective motivations of municipal officials. That's problematic for a court, certainly problematic for the committee.
But the fact of the matter is you're saying that even if it is a property interest, you can still treat it as if it's not.
Let me give you our precise argument is that it loses under this bad faith concept as the court has developed and we believe is a reasonable development from Chelmsford Pheasantry, it loses its pure private property designation and becomes a local regulation or requirement that therefore can be overruled. The whole issue in Chelmsford was this a local regulation or requirement? The facts there clearly established there was good faith. And it said in there, we're going to say it's beyond the committee's jurisdiction because it's not a local. But it made very clear that were the facts different, were good faith negated, it might well have had a different result, and the committee might well have had jurisdiction. So that's our theory.
You're focusing on purity at its creation, not purity in its application.
At this, that's the primary, that's what we've propounded brief. The amici have raised a further extrapolation into looking at good faith at the time of usage. Our issue there, just to put forth for the court's consideration, is it would be, if that were adopted, it would be contrary to the result reached in the Groton case. Because while, again, there was no dispute in Groton that property had been acquired in good faith, the way the town subsequently exercised it by denying the developer the right to go on the property was clearly motivated by the desire to block an affordable housing development. In fairness, good faith wasn't raised explicitly one way or other in the decision, but the result would be there. So the amicus makes a fair point about the analogy between use of the taking power and use of private property rights. I concede that. I would simply note that on the other side is the actual result in Groton. Again, the committee feels bound. It got the court's point 10 years ago to take private property very seriously. It's doing so, and that's why we feel that in these very narrow facts that Groton would control. But above all, we urge the court to issue a limited ruling that does not open a can of worms inadvertently for further use by municipalities of ways to get around the statute.
All right, thank you.
Thank you, Your Honor.